You brought a lawsuit against your doctor for medical malpractice. You claim he was careless, causing you significant harm and injury. Your case goes all the way to trial. And now you're about ready to cross-examine the defense's medical expert. And the doctor refuses to acknowledge that a textbook is actually authoritative. Can I go ahead and continue cross-examining this doctor about this textbook? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now we're at trial. I'm about ready to cross-examine the defense's medical expert. The doctor whom you have sued hired a medical expert to defend this case. And now I'm cross-examining the doctor. And now I show him a textbook. Doctor, you recognize this textbook, don't you? Yes. It's a textbook of the Annals of Surgery, isn't that true? Yes. And this is something that you trained with, isn't that true? Yes. When you were a resident, you used this textbook, isn't that true? Yes. Doctor, do you consider this textbook to be an authority? No, I don't. Really? So now it used to be that if a doctor did not recognize a particular textbook as being authoritative, that meant that we would not be able to use it to cross-examine him. Even if we said, Doctor, I understand that there are lots of information in this textbook, and I'm going to go ahead and give you the right to disagree with certain parts of it. Will you still agree that certain parts of it are authoritative? If the doctor still said no, then we were actually prevented from asking the doctor certain questions, so I couldn't turn to a certain page and say, Doctor, at page 271, do you agree with this statement by Dr. Jones? We would not be permitted to do that. Why? Because the doctor would argue that this textbook, the information in it, was out of date. He would argue that the moment it gets published, it's out of date, and new things come out all the time. So although it may be instructive, it may be a guide, maybe residents and other doctors use it to learn, it's not technically the guideline, it is not the authority. So we would have this battle over words of whether or not a textbook was authoritative. And every single doctor who got up for the defense, and for our side as well, always knew that if they said, hey, this textbook is not authoritative, that meant that we would not be able to use that textbook to cross-examine them. Well, that's changed a bit now. That whole perspective has changed. There was recent case law which basically said, listen, if we ask a doctor if something is authoritative, the mere fact that he says no doesn't mean we can't question him about it or ask him certain information about what's contained in the textbook. So let me give you an example. If we ask the doctor, is the information generally contained in this textbook, is that reliable? We can ask him that. Do you use it, doctor? That's another question that we can ask. Is it a standard text that you personally rely on? Now, is this a textbook that when other doctors or other residents, doctors in training, ask you for information and resources, you will give them this textbook? Isn't that true? Yes. And doctor, is the information contained in this textbook, is it clinically useful? Yes. Now, if we can get the doctor to admit and agree to all of those questions, now instead of him agreeing that, yes, this is technically authoritative using that word, by asking him those other questions which show that this is a textbook that is used, it's relied upon, it's reliable, there's great information in here, and doctors in the community use this all the time. Now we will be permitted to ask the doctor questions about information contained in there. Obviously, we're doing it because there's got to be some information that's helpful to our case about the standard of care and about what was done in this particular case. So now, in that instance, the jury will then be able to evaluate the doctor's credibility and whether or not what he is saying is true or not true. So the courts have now allowed us the ability to get around that word, which basically said, hey, listen, if you don't say it's authoritative, we can't ask you anything about this particular textbook and the information that's favorable to us in this book while we cross-examine you. So why do I share this great information with you? I share it with you just to give you an inside look at what happens in a medical malpractice case here in New York. You know, I recognize and I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.